Thank you very much indeed for having me here today. It's an absolute pleasure to be here. And I probably shouldn't say this, but one of the reasons is because I have a 3-month-old daughter. And yesterday in the hotel room was probably the first time in a very long time that I got a good night's sleep. So if anything, thank you for that. So it's very good to be your after-lunch entertainment. Hopefully I'll keep you awake. And what I'm going to be talking about is the broad strokes of the changing picture in AML enforcement in the UK art market. Yes, there'll probably be a few puns going along in this presentation. So by way of overview, what I'll first do is set out the problem in this market, then talk about the UK's solution, whether that's actually brought about any change, and then difficulties along the road, both for the regulator and the regulated. And one of the insights I have through my practice is that I both act for regulators and I also defend. And both of these parties have faced difficulties in this journey. And I'll also then touch on what the future in this space might look like. So what's the problem? Well, essentially, if a money launderer could come up with a playground in which to money launder, it would probably look like something like the art market. It is essentially a dream setup for them. And how so? Well, because of all of these hallmarks. So it is a significant market globally. Currently, it's assessed at a value of 57.5 billion. And that size means opportunity. Firstly, because there's an awful lot of art around. It is essentially a universally valued item across regions, across cultures, whether you go to Maori populations in New Zealand all the way up to Native Americans on the Great Plains. They have art. It is a valued item across the globe. So there's a lot of it that can be used for money laundering. And it is a big market, which means that if you do engage in that kind of activity, there's not going to be an immediately obvious spike. So there is opportunity for money launderers in this space. There are also significant values. So essentially, you can move and launder a lot of money through a single transaction because a painting quite regularly can be 50,000, a million, if not more. Traditionally, and even to this day, it is a market that is characterized by secrecy. We've probably all seen the image of somebody on a phone in an auction room doing bids on behalf of a secret buyer. The market is totally characterized by secrecy. It is also characterized by subjectivity. Essentially, whether you think something is worth something in the art world can boil down to whether you like it or not. And money launderers can use that as a way to inflate the price or indeed deflate the price so that it can move across borders without engaging particularly high customs duties or taxes. Another attractive property of the art market and art is easily stored and it's easily transported across jurisdictions. So unlike real estate, where it can be bound up quite heavily, it's quite easy to put a lot of money into a small A4 size piece of art, store it somewhere, and then if you need to move it, you can do that at ease. The other quality of this market that makes it attractive is the status that it affords criminals. And essentially there is inherent status. So we'll come to one of the headlines where criminals like to own a Banksy. It's something that goes down well in their world, it seems. But on a more financial footing, it is also something, a commodity that they can use to make money for them whilst it's not doing very much. And in particular, it can, for instance, be used as collateral for loans. So how might money laundering play out if you are a participant in the art market? And by way of definition, and we'll get to the legal definition, but you can view participants in the art market as galleries, auction houses, intermediaries. Well, if you are selling art, you could end up selling art that is stolen, looted, or purchased from the proceeds of crime. And if you are buying art for someone, it could be that the art is being purchased using criminal funds. Another really significant factor is the use of free trade zones and free ports in this area. Essentially, a free trade zone or a free port is a physical site where art can be stored, and whilst the art is there, there can be transactions which won't necessarily incur taxes or customs duties. So essentially, the assets are kept out of reach from law enforcement. And a typical typology that you might see is within a free port or a free zone, the art might be sold multiple times. The price might be inflated, or indeed it could be deflated, and the original money launderer is far removed from the transaction because of the multiple layers of sale that have occurred, and then eventually it leaves the port, and at that point it might come into the purview of the law, but by that stage the original money launderer is far removed. And just to outline that this is a very real problem, you see a number of headlines there. The one that I'll touch on, because it sort of illustrates what a funny world we live in, is the Mexico example. So that's from the Washington Post, a 2014 article. Mexican art galleries suffer as drug money law ends anonymous cash buys. And essentially, when Mexico introduced identification rules for art purchases, its art market shrank by 60%. And it was suggested that the reason for that was because essentially drug dealers were laundering money through art purchases. But what it makes me smile slightly is what the galleries had to say about it. And the galleries said that the reason there was this contraction in their market was because their clients were worried about their safety. They felt that they had a fear that corrupt officials in the government might leak or sell the information that their clients had a lot of money available to buy art. So you kind of can't win either way. Either there's a lot of money laundering going on, or there's a lot of corruption. The other story that you may have come across is from everyone's favorite afternoon television program, Bargain Hunt. There was an individual who was an expert on bargain hunt who was recently jailed for 2 years and 6 months, and that was in relation to failing to disclose knowledge that the person he was engaging with was a suspected Hezbollah financier. So what's the solution in the UK? Well, since 2020, the 10th of January 2020, art market participants have been brought into scope of the money laundering regulations, and the legal definition to bring you in scope is any firm or individual who trades in or acts as an intermediary in the sale or purchase of works of art over 10,000 euros, or is involved in the storage of art worth over 10,000 euros in a free port, will be within scope of the regulations. And it also applies to linked transactions. So if the money launderers try and just get under the 10,000 euro limit but have a number of transactions, they'll still be captured. Or if they try and fragment the piece of art, so they say, well, this collection is actually, 3 paintings worth 4,000 euros, that won't work because they would eventually cross the limit. And also it applies if you try and fragment the transaction by having linked buyers, they will still be captured. And as I say, it applies to some of the obvious contenders, galleries, auction houses, and online sales companies, but also slightly left field. You can see that interior designers, for instance, may be captured when buying or selling within that 10,000 euro limit. And I think what this definition shows is that a lot of galleries and a lot of participants in this market will be captured, because the €10,000 limit is actually relatively low when it comes to a lot of art. And we'll get onto this in some of the other slides, there's been a huge swell in, say, seaside galleries suddenly being captured by this huge wall of regulation that it can feel sometimes for them. I should say that there has historically been regulation in this sector through POCA, but what has essentially happened is that the supervision and enforcement now is governed by HMRC, and there's a greater degree of compliance oversight and compliance requirements. And some of these are summarized on this slide, and I'm sure a number of you will recognize all of these things from your typical regulation of a financial institution in the AML space. But now, if you are, say, a small art gallery in Worthing or wherever you might be, you suddenly have to register with HMRC, you have to have a business risk assessment, you have to have a range of your typical policies and procedures, you have to carry out CDD, you have to have MLRO, training, SARS reporting, and record keeping as well. And you can imagine that, say you are someone who decided, well, I really like art, I'm going to set up a small gallery by the seaside. Suddenly, from 2020, if you are crossing the relevant thresholds, which are quite easily crossed, you have to deal with a lot of this. When looking at the regulations, another really important thing to take into account is the question of what is art? And that's sort of a philosophical question and probably another presentation, but the lawyers aren't that philosophical, and we've gone straight to the Value Added Tax Act of 1994, and there is a very prescriptive list of what falls into the definition and what doesn't. And there may be in the future, when we talk about reform, some movement on this, and there is, to some extent, some subjectivity. I remember talking to someone about the fact that technical drawings are not considered art, may be subject to discussion, because you could, for instance, have, say, a technical drawing of a Concorde aeroplane that some people might say actually does capture a lot of value and may start falling into the concept of art. But at least from a sort of a lawyer's or regulator's perspective, at the outset, just with any regulated issue, when you think of the perimeter that you're active in, that's often the first question. Are you dealing with art? In terms of the solution, there's obviously a sanctions regime, civil and regulatory, as well as criminal. On the civil regulatory side, a penalty of an amount that's considered appropriate. So essentially, there's no cap, a public censure. And then on the criminal side, if you are before a magistrate, again, unlimited fine and a term not exceeding 3 months. On indictment, so before a jury in the Crown Court, you would face a term not exceeding 2 years and potentially an unlimited fine, or both. Now, it might be said that these penalties don't look particularly onerous, especially in terms of imprisonment. But I think the two things to remember is, firstly, the size of many of these businesses that are involved. They're not particularly big, and they can face an unlimited fine. That's significant. And also, as I was saying before, if you are someone who decided, I'm going to set up an art gallery, and suddenly you fall into the scope of these regulations, and suddenly, because you didn't do something, you might be facing 3 months or 2 years in prison, that is significant for those individuals. So, has it brought about change? Well, I would say yes. And in the regulator's eyes, there certainly has been a degree of positive change. So the UK's latest national risk assessment came out in July this year, and actually the rating has moved for money laundering from high to medium. And HMRC says that the reason for this is because of their improved understanding in the sector has allowed them to respond and decrease the score, although there remains a risk. The rating for the art market being used for terrorist financing has stayed low. And part of the reason for that is that it seems that whilst, and we saw with, for instance, the Hezbollah example from Bargain Hunt, that it does go on, but part of the reason it's low is because it's considered that essentially there is a level of complexity involved in whether you want to money launder through the art market. You need to have some sort of understanding of art, and the National Risk Assessment seems to say that terrorists aren't that interested in developing that understanding. So that's why that's low. The other great victory, according to the NRA, is the registration. So we now have 1,337 registered art market participants, which is significantly up on the 208 in 2020. There has also been a fair amount of enforcement action. So in the initial few years, the enforcement action was largely confined to the registration, so whether an art market participant was registered with HMRC or not, and they weren't necessarily going after breaches in terms of policies and procedures, SARS and so on. And the penalties for that registration side of matters, that totaled just over £500,000, which we might consider is relatively low given the size of the market, given the number of participants. But what we are seeing from the latest penalties that have been published is that the enforcement action is getting a lot more sophisticated and the penalties are increasing. So I think in the last round of publications in July, there were 2 art market participants that individually were each fined something like £150,000. So you can see that's ticking up considerably. And in terms of the issues that are identified, they're seeing insufficient risk assessments and issues in terms of reporting. And we'll get on to why those are some of the problems we're seeing in this space. And just to put a bit of life on the change, these are some of the press reports. So this Politico piece, which I'll turn back to because it actually is worth reading because it's various interviews with people in the market. They're certainly feeling the heat and they're fuming at this apparently. And you also have a trade paper saying that the enforcement is ramping up. And I'm sure the people at HMRC and the regulator would have also been very happy to see that they were in box number 1 of a country example of regulation in this space in a recent FATF report on terrorist financing and money laundering in the art world. So I'll turn to difficulties now for both the regulator and the regulated in this space. And I think the first thing to say is for the regulated, they have put a lot of effort in this, but it is difficult because it is hugely resource intensive for a lot of these smaller art market participants. Essentially, these can be businesses that have maybe 3 or 4 employees who are not only dealing with their actual business, but they now have to deal with all of the compliance measures that we looked at. So it is hugely resource intensive in terms of staff. There is a cost associated with compliance visits, both in terms of hours out of their day and the follow-up, and that has an implication on these real-life businesses. There is a cost in terms of compliance tools as well. So often, the conundrum that they face is they don't know anything about this world, so they'll go out and buy a CDD tool that they think will help them, and the regulation operates in such a way that you can't outsource your regulatory obligations. So they're in this reliance conundrum that a lot of people face in the regulated sphere. And that's challenging for them as well. And then there's the broader economic picture. So a lot of businesses in this space are feeling inflationary pressures. They're recovering from a COVID slump. There's been national insurance increases in the UK, and their customer base is also feeling the heat and can't buy as much art as they once could. And the link into the regulations is that if HMRC comes along and they want to slap on a big fine, but the regulator can't afford it. Under the regulations, you need to take into account the financial implications and the financial strength of the business. And so you end up in a difficult position where the regulator can't do what it wants to do. And if it does, then the whole market may face significant challenges, and it puts the law in a difficult position in terms of its credibility. In terms of cultural implications, turning to the regulator, one of the things that I see in my practice is that HMRC has done a good job in ramping up its professional capabilities in this space. It's got a lot of people doing this, but it seems that the mindset is one that is used to dealing with large businesses or financial services firms. And essentially, HMRC might come in and expect these firms to be able to respond to a compliance visit in the same way that a large business might, that they can throw the resources at it, that they might have insurance policies to cover it, that they may have a contingency for a fine, that a fund for that, and simply these businesses don't have that. And what this means is that it can be an incredibly stressful process for the art market participants that are going through a supervisory or an enforcement process. And again, there is a link back into the regulations, because the regulator does need to take into account the impact on the individuals that are going through this process. And again, this impact, because of a slightly heavy-handed approach, can lead to enforcement action slightly hitting the rocks. Another issue that's flagged in the National Risk Assessment is, whilst HMRC has ramped up its capabilities, and the Metropolitan Police in London does, broader law enforcement probably needs to become a bit more attuned to the risks in this area. As I said before, the art market participants, in my view, have tried to devote a lot of resource to this, but on their side, there are some negative cultural views as well. And you can see the summary there is they view the regulations as excessive and uneconomical, and interestingly, insensitive to what is ultimately a relationship business. And I'll turn back to the Politico article, which has some more colourful quotes on this. And you can see the first quote, which is an art market participant essentially saying that they think the regulation is a pain in the backside, highlights its onerous nature. The other quote, the second quote, is essentially around this being a regime that is culturally awkward for the market in which it operates. And it does raise an interesting question, where you have a market that depends on relationships. It has a way of doing business, and of course it should change and adapt and properly respond to the threats. But equally, there are question marks over how the regulations work, if it is totally or fundamentally incompatible with how a particular market might work. And there are some interesting stories about customer due diligence, for instance, where art market participants might find it difficult to ask some of these awkward questions in a regulated way, but actually as part of their business, they can be incredibly snooty about who they want to sell art to. So they do end up with an awful lot of information. And certainly on the defense side, what I've experienced is that when you dig deep, there is actually an awful lot of CDD, but done from a slightly different perspective. And you can then navigate the conversation with the regulator in a particular direction and potentially push matters to, say, a record-keeping issue rather than a substantive failing. Another issue is speed. And again, the purchase of art, especially at the high end, can often be an emotional thing where somebody sees a piece of art and they want to buy it, and that's how the market operates. And then having to go through a process where you have to wait for a number of days for a sale to occur can be challenging. And all of these challenges have to be viewed within the overall international dimension. And that is that essentially they operate in an environment where there are international disparities. So the UK's National Risk Assessment makes this very clear. They say other leading markets in the world, notably USA, so New York, China, Beijing, they don't have this kind of regulation. And as the chairman of the British Art Market Federation says, and that voice is important because the British Art Market Federation produces the guidance in this field that is essentially blessed by HMRC. He, in this quote, says, well, ultimately, if you're going to have this disparity where people can go shopping for their jurisdictions, then people will just go elsewhere. So what might the future look like? Well, on HMRC's side, and this is a quote from someone who was interviewed by Politico, it seems like the honeymoon period is over. They're going to crack on. And as I was saying, in terms of the fines that we're now seeing, we're moving beyond are you registered, and the enforcement action is looking at policies and procedures. It's looking at the stuff that's going on beneath the hood. So that's going to accelerate in pace. And with that comes a danger that where you have a particularly active regulator, that what you might see, and there's a risk of this, and we saw some of this in the cases that followed after the financial crisis, is that substantive and procedural fairness can on occasion be compromised, and you wouldn't have a presentation from a lawyer without at least one case, and that is an impermissible approach, where essentially what you might have is a regulator now with a great awareness of the risks in the market suddenly transposing this on conduct that occurred before that awareness existed. That sort of application of hindsight is dangerous. It's something that I've seen in my cases, and it is something that rightly is improper and needs to be resisted. So what might the future look like? Well, one area that is most likely going to see regulation, and it's mentioned in the UK's National Risk Assessment, is antiques and antiquities. So that's essentially objects that are older than 100 years or very old, so Grecian, Roman, sort of over 1,000 years old, but not considered art. And that's kind of interesting division. That is currently unregulated unless it's been purchased for in cash above 10,000 euros. Then it fall within the high value dealer provisions. But at the moment, that's unregulated. But in many ways, those transactions carry the same risk as transactions in art, because you can store and move large sums of money in a single transaction, and you have the portability as well, because they're small, easily transportable, can be stored at Freeport. So that's likely to see a level of regulation. And you also wouldn't have a modern day presentation if there wasn't any mention of blockchain or AI. And again, this is a space where you might see some regulation. So NFTs, non-fungible tokens, which are essentially unique digital tokens that can represent a unique item such as art, that may fall within the perimeter, as well as AI-generated art, which currently sits outside of the regulatory perimeter because it's not executed by hand. Again, what we're seeing is that people can store value in these items, they can be transported, they can operate in very much the same way as traditional art, and so they may fall in the regulatory perimeter as well. Interestingly, there is a push potentially for deregulation, and this comes from two areas. One is a lot of the regulation in this space actually comes from 5 MLDs, so an EU directive. The United Kingdom's no longer in the EU, as we all know, and essentially there is a push by those on the Brexit side of the argument to say, well, this is an ideal space where we could, say, use our newfound freedoms to deregulate and be competitive with, say, New York and China and Beijing. In my view, I think it's highly unlikely that there's going to be wide-scale deregulation in this area, but what I can see, what I think the British Art Market Federation has raised, is to address this disparity where the seaside art market participant is treated in the same way as the international auction house. And there could be potentially some movement in that space. And the other aspect that we will probably see some more movement on is international alignment, because again, there is a sense that there's a high level of regulation in the UK now in this area, but there are jurisdictions that have a significant footprint in this market, in cities, New York, Beijing, which operate here, which don't. And without international alignment, you essentially have a regime that's full of holes, and one country is deeply uncompetitive, and overall the international risk of the crime doesn't decrease. And that's all I wanted to say about the art market and the UK's enforcement in this space. Thank you very much. Depending on what the criminal wants to do, you do sometimes actually want to decrease the price quite significantly, because then you can move it across the borders without getting involved in taxes or customs duties or decreasing that. And art is perfect for that, because you can do that because of the subjectivity. And then suddenly it pops up in a new jurisdiction. There's great interest and can kick up the value. So it's a money launderer's dream, really.
And the interaction, I suppose, between a business that perhaps, or an industry that hasn't been used to that kind of quite invasive often enforcement activity. And it's intriguing to think how those relationships might evolve over time, where you have a fairly potentially hard-nosed enforcement person dealing with an art dealer who hasn't really had to deal with that level of investigation before.
Absolutely. And I don't know if I read it out, but the line that often comes up is, "We're not detectives." And you might have an individual working in an art gallery, and suddenly, because of HMRCs coming in, they're looking at a piece of art that might be sold to an individual who's then put it in a trust. And then you have to look through the trust, and there's essentially this individual who just likes art. And now they have to look through all of these various structures, many of which can be offshore. It's a huge challenge for them. And they say, well, yeah, I am not a detective. I just sell art.
Really unique perspective. Thank you so much, Nikesh Pandit. Thank you.
Bye.